Hey guys, I'm Fancy.
And I'm Colleen.
And this is Murder by Design. Alrighty, folks. Well, welcome back to Murder by Design. We are so excited to have a special guest tonight. We have Kirk Nurmi with us. If you guys listen to our Good Wives Guide to True Crime, you're going to hear him on there talking about his time as a defense attorney for Jodi Arias. He wrote a book all about it, and so we're really excited to have him tonight. So welcome, Kirk. If you just want to tell everybody a little bit about your background and who you are, since our listeners haven't got to see you over here yet. So.
Oh, sure. Well, I was a criminal defense attorney in Maricopa County for 15 years, handling lots of serious cases. And then most people came to know me on January 2nd, 2013, as you pointed out, when I was working as the lead counsel, as a death penalty qualified attorney for when I was assigned the Jodi Arias case.
Right. And that was an interesting case. It changed your whole life, right?
Well, yeah, there's no doubt about it. After 15 years of practicing law and then moving into the death penalty cases, all the cases were serious. But that case was certainly something like I'd never seen in my career before, and like really, it's pretty rare for anybody to see, to have that high profile a case, especially occurring in the social media era. When we think of other cases like that. O.J. Simpson, for example, wasn't in the social media area. Casey Anthony was, but by the time we got to Miss Arias's case being live streamed, it was the kind of deal that everybody could watch from their phone or on their computer all the time. So yeah, it became a huge sensation and definitely a life-changing event for me after my 5.5 years of being trapped with Miss Arias. The titles of my book are there for a reason. It's
Sure.
Not just made up. I really was trapped. I was there by court order, and 5.5 years, from that assignment, or approximately, I was relieved of duty when she was sentenced in mid-April to life in prison.
Wow. And now there's still stuff going on with that case, though, right? I keep seeing it pop up every once in a while.
Well, she had her appeal, denied recently, and there's still certainly interest in that. And I know that once her appeal's denied, she can file a motion in court claiming that I was ineffective as her counsel, that I didn't do certain things, what have you. And that'll probably come up sometime in the near future as well. So, it's like some of these seminal cases or seminal criminals like Ted Bundy or OJ or any of these, they just don't seem to completely go away.
Yeah, very true.
Yeah, I talked with Diane DeMond the other day, who broke, she was one of the journalists that broke the Michael Jackson case back in the 90s, and she covered it all the way through his death and everything, and she said the same thing. It just, like, every time she thought she was done with that case, it would pop back up, and she'd have to go out and do a whole nother slew of interviews and talk to people and everything. But so, yeah, we definitely, and you're right. The new social media, I think it's caused a new fascination with these cases, that it's so readily available now. When we first were watching, like you said, OJ and those cases, we got a little bit of coverage, some of it, was covered on the nightly news. I think there was some all day coverage on one channel on cable, but we didn't have like what we have today, where it's just covered nonstop.
Well, and now with social media, it's on demand. You don't have to be DVRing it on your cable or, tuning in on the nightly news every night. You can just pull up, CNN or,
Crime or
anything, and it'll be right there.
So we've got a popular case that's going on right now, and when I told you we were going to talk about it, I heard your little sigh. So it's kind of the bane of everyone's existence right now. And I think there was 3 cases that were really kind of vying for this like worst case right now, which was Evelyn Boswell and Leticia Stout, and then of course the one we're going to talk about for a little bit here is Lori Vallow. Now, as a defense attorney, what are your thoughts on this and how it is unfolding in the court system?
Well, that's such a broad question because the case is so broad, right?
Right.
Because we have, Mr. Daybell's ex-wife, I think Tammy was her name. She died. We have the two kids died. The brother has passed away. So I guess, from the outside looking in, and there's always more known on the inside, right? I've been on both sides of the curtain, and now I'm on the outside looking in. We know that there's a lot more going on than meets the eye. And I think, it depends on whose defense attorney I am, right?
Right.
If I'm Lori Vallow's defense attorney, I was thinking about this today when we're getting ready to have this conversation, is that, she was arrested in advance of him about a month, 6 weeks maybe, right?
I think
a few months.
Yeah, actually she's been held for quite a
few
bit of
months.
time. Yeah.
Yeah.
And so with that, and the charges were child abandonment, relatively minor considering what's going on here today. So my guess is there's a lot going on behind the scenes. And, if I'm Lori's attorney, I'm looking to, do everything I can, depending on, obviously not knowing what the client is telling the attorney, right? But those charges are probably a way for law enforcement to begin twisting the screws on her, on Lori. And we might have seen that come to light with the discovery of the bodies in the backyard.
Now, go ahead, Colleen.
I was going to say, so if you were Lori's attorney, how would you feel knowing that she has implicated herself in a way by pretty much saying that the bodies are in the backyard of Chad?
Well, we don't know the
Exactly
circumstances of what she's saying, right? Exactly what she's saying, or what involvement, her current husband now had in this situation. So, look, and again, it goes back to this question. Defense attorneys function under a common misconception that a couple of them, one that the client tells them the truth, which isn't always the case, right? And then when they and then that attorney goes out and the attorney and the client scheme together to make up a story.
Right.
And that's not the way it works, right?
Right.
The defense attorney has some facts that he or she is being presented with, and they have to work within the parameters of those facts. So, exactly how I'm feeling about it is hard to answer, other than, look, we don't endorse criminal defense attorneys, and this is the other misconception. Criminal defense attorneys aren't endorsing crime. They're there to support someone's constitutional rights. Absolutely. So, that's what they're there to do, and they're there to, mitigate the damage, and they're there to maybe cut deals, et cetera, et cetera. So that's where their defense attorneys are probably looking at this case. And again, we're on the outside of the veil. We don't know exactly what links there is between the deaths of these two children and Lori or her current husband, right?
Well, you would think we would be further into this case, but we're just not. And then, okay, so here's my thing.
Well, I think. Oh,
go ahead.
Go ahead.
No, you go ahead.
I was gonna say, I think they're probably further along than we know. That's the point. And one of the reasons we sigh when we talk about this case too is because it's a big web, right? And because it involves so many people in different states. And one thing that I don't hear talked a lot about in the media is, look, we don't know where these children were killed. Were they killed on federal land in the park? Were they killed in Wyoming? Part of that park is in Wyoming. and part of that park is in Idaho. Were they killed in Idaho? We don't know. So it's a big web, and I think they're probably farther along than we know.
Sure.
But that obviously, as a true crime fan, can be frustrating.
Well, here's a question I have, though. Currently, they both have the same lawyer, Chad and Lori. Is that odd at this point, or do you think that that's going to change at some point? Because that was one of the things why people were saying, well, she didn't roll on him and say where this was or that was. They were trying to say that maybe, they pieced it together from their conversations, or that the neighbors had tipped them off to saying that there was lots of bonfires and they were just waiting for the snow to clear. But they still currently have, at this time, the same attorney. Is that a conflict of interest? Is that going to change, you think?
Well, I would think it's a pretty clear conflict, and I wasn't aware that they had the same lawyer. I would think that's a pretty clear conflict because, and right now the charges are, not murder, right? We have, I can't even remember what the dad is charged with, but
he's charged
or
with
the husband.
2 counts of tampering with evidence, and one charge tampering with evidence, and then one charge of concealing evidence. So far, like you said, we don't have any murder charges. With all the dead bodies we have stacking up in this case, we have no murder charges anywhere, and I'm worried that that's going to be like this pointing of fingers in so many directions, like the scarecrow, which way did he go, and you go both ways, because it seems like it's really a big fester for, well, my brother did it. Well, no, Chad did it. Well, no, Lori did it. Well, no, so-and-so. So I'm just concerned about that. But them being with the same attorney, that just seems odd to me this far into where we're at. Yeah.
Well, right. And technically right now, my point is technically right now, the charges aren't in conflict. Mm-hmm. But they're really, as far as I'm concerned, they really are, because, that attorney, if he's being open and diligently defending both, can't conceal information from a client, right? And so if Lori were to roll, then he would be well aware of it, right? Yeah. In theory. But that doesn't mean she didn't. And the attorney should definitely have separate attorneys. And I think eventually we will see that being the case. Once murder charges are brought, there would be, in my mind, no dispute about the fact that they should each have different attorneys.
I'm happy that the judge continued to refuse to reduce her bail this entire time. And it's like, produce the children and I'll reduce your bail. That's the only charge you're here with, is failing to produce the children. Produce the children, I'll reduce your bail. And she couldn't do that, and I mean, we now know why. There's such a flight risk that I'm glad he did refuse to lower her bail, because who knows where they would have ended up.
Well, my question is why she's not using the portal, but whatever. So.
Why she's not using what?
Her portal. She talks about she's got a portal.
Yes.
I'm like, why is she not using the portal? If you're such an almighty whatever that you've got portals, like, why are you not using it? Why are you not using it? No, I'm just kidding. But, it's such an interesting case in all the moving parts. I feel like we're going to see a lot of really crazy stuff happen with this legally, and as it unfolds. I'm just wondering what you're anticipating happening.
Well, I do anticipate what you just said. I mean, I think a lot of finger pointing, and I think the big key, as I see it, is going to be the toxicology reports. Because if there is, a similarity between the manner of death, and I would suspect, if I was, going to make a guess, I would say the most likely cause of death is some kind of poisoning, because it portrayed itself as natural causes. And the ex-wife. So if he finds a way to, Mr. Daybell finds a way to poison people and make it appear natural causes, Lori is going to probably, this is why I say probably turn. If the toxicology report shows a similarity in those manners of death, the same chemical compound, then I think it'd be really easy for her to point the finger at her husband. So I think the toxicology and the commonality is really what's going to guide this case, the manner of death, really, I think, because if there's any commonality outside the kids, then it becomes real easy for her to say, I was this innocent victim of this man, of this cult leader, and he got me to say these things.
Right?
He killed my children. He brainwashed me. Yeah.
Yeah.
He killed his wife
and that
same way.
Yeah.
Yeah, I'm just wondering if the brother and the ex-husbands and the ex-wife are going to factor into this all at one time, or if they'll take them case by case. I mean, this is probably one of the biggest, strangest cases that I've seen in a long time. Gypsy Rose Blanchard was pretty crazy with all the different medical things and everything that we dealt with that, but this case by far has been like a roller coaster of, oh wow, okay, So,
well, it's expansive. There's so many states, there's locations. Hawaii got thrown in there. There's dead siblings, dead spouses. It's gonna be I think this is gonna be a long trial, a long case.
Do you think they'll take them one by one, or do you think it will come into play of like a multiple counts of different things in different pieces of this case?
Well, that's a hard question to answer because it depends on how linked they are. We talk about the brother and Miss Vallow's ex-husband, right? That's obviously all that thing happened in Arizona. It has nothing to do with what happened in Idaho, so it couldn't be combined, or Wyoming, Idaho, maybe it couldn't be combined. But that also too could just be coincidence, right? I've read some stuff where her brother was quite a violent guy. It could have nothing to do with these killings, right? It could be related. Again, we're going to have to wait to find out. But as far as the trial goes, judicial economy, if there were murder charges, would be related to trying them both together, or maybe if the speculation that she has turned, then she would be a witness, not a defendant. She would take a plea, and there would be a trial just for him. So, as big a mess as it is, and as anxious as we want to know where this thing is going, that kind of theme and the motive and the manner of death is going to have to come together before the legal, process trails along.
Well, I do have a question. You said the two weren't related, and if it's the brother, and then the kids, but there is a possibility that it is in some way related. That it's speculated that Tylee witnessed what happened with, I think it's Charles Vallow. I think it's the father of the adoptive father of JJ, being killed by her uncle, and that is suspected as to why possibly Lori decided that she wanted to get rid of the children. So if that comes up as being a motive for the other one, does it then connect the two together in a more conclusive way legally?
Yeah, and maybe I wasn't clear. I said it might not be connected.
Right.
They may be completely unrelated. But and the point I was making as a follow-up to that is you ask about a combined trial, and because of jurisdiction, there couldn't be a combined trial.
Sure.
Could it be evidence of motive? Yeah, sure. Could the authorities from Arizona go to, say, Idaho or Wyoming or federal court and testify about this murder as evidence of guilt or motive? Then certainly they could talk about that in terms of motive, and then there would be, if we were to say that that's the reason, then there could be potential for charges in Arizona. Well, although the brother is dead now, so it would be hard to see what would be charged in Arizona. But be that as it may, yes, it could be evidence.
Sure. Sure.
That makes sense.
And then the only other thing I really want to know is, some people have brought up the question of due process through COVID. So a lot of in the Durst case, even that we're seeing right now, he filed a motion because he doesn't feel like he was given due process because COVID, shut down all the courts. How do you feel that legally could come into play in some of these cases that have been delayed so long because of, the court systems being shut down for quite a bit of time?
Boy, and I'm not familiar with the exact argument he made, but it really depends on the type of case, right, and the length of delay, because we're talking about memories lost, memories fading. I've had cases that were charged years later that I've made the argument, look, the recollections cannot be as clear, you can't get a fair trial, and that doesn't seem like it's something that would come into play in this case, simply because I think this is going to be a case of forensics and a case of one of them turning on the other, and whether or not the police and the jury believe it. So I think that's a hard argument to make, especially, when we're talking about, I've made arguments in cases where work records have been deleted like 5-6 years later that I thought were strong arguments that the case should have been dismissed. But when we're talking about just faded memories and the passage of, let's say, even a year, it's hard, I think, that for a defense to convince a judge that is motivation enough to throw out a murder trial. Sure. Now, if a witness died because of COVID or something like that, then that's a different story. But I think the length of time we're talking about is not significant or sufficient enough to really have that be a winning argument.
Right, like postponement of trials, in the 5 to 1 year timeline of postponement, versus people waiting in jail or on death row for 15 years.
Which leads us into
our
next.
I know who you're talking about.
And I just have to preface this before you start. Colleen actually thinks that Scott Peterson is not guilty. I think he's guilty of sin. I have looked at everything, but I haven't looked at it from a legal standpoint, which is one of the reasons why we kind of wanted to have you on here tonight. So I'm going to let Colleen kind of take the run with this, because I have a feeling that you guys might line up a little bit more than I will.
So,
well, I don't know about that, but let's hear the pitch.
Well, so we were on Web Sleuths last night. So Wednesday, the June 17th, and it was this kind of the same scenario where most people believe that he is guilty, and I believe he's innocent. But for me, I don't think that there was enough evidence of guilt for him to get the death penalty, just because there's lack of physical evidence and just a lot of circumstantial evidence. So I've got feelings, and usually this is like the one case that Fancy gets on me, because I'm typically, you look at a case, I'm more on like the prosecution side, like guilty, XYZ, guilty. And for Scott Peterson, I can't. Just for me, there's just not enough to say that he killed his pregnant wife. I think he was a really crappy husband, but I don't think that means that he killed his wife. And so I'm just going to say, before we get into the case thing, I'm sure you are, but are you familiar with the Scott Peterson case?
Not overly, no. I mean, I'm certainly up to date on his appeal and what's going on, but in 2002, I was a practicing lawyer with my own problems, so I'm familiar with the basics, if you will. But if you're gonna talk about specific bits of testimony or something, then you're gonna lose me. But I will say, look, there's two kind of levels there to the argument you're making. One relates to the verdict, and the other relates to the sentencing, right? And because and I think even those people that believe him to be guilty And I really don't know, right? Because it would have to concede that it's a case strictly of circumstantial evidence, right?
And let me start there.
I mean,
let me interrupt you before you get into that, because I want to explain, I would like you to explain to us how common it is to have a case that's very, common or not common, that's very based in this type of thing, like very circumstantial. There's not like DNA or fingerprints or anything really concrete that ties it all together for us. How often is that normal? And what kind of case, tell us a little bit about what you think of that being just a very highly circumstantial case.
Well, it can be, it's not, I wouldn't call it normal, but I wouldn't so far to say that it's rare, that it's abnormal. But I would say it is abnormal in a death penalty context, because typically in a death penalty case, guilt is basically a done deal. There's forensics, there's a confession, whatever there is, there's motive, there's, clear motive, opportunity, all that stuff. That's all wrapped up in a bow for the prosecutor. And then the question just really is, should the person die for this crime? So in a death penalty context, it strikes me as being very rare that a prosecutor goes after death when circumstances are the only evidence.
And why do you think that what do you think was the motive or the idea behind that, and why do you think they got that?
Well, we hear the arguments, being made about pretrial publicity. And like I say, not overly familiar with the case, but I'm wondering, how much the court of public opinion factored into the prosecutor's decision to seek the death penalty against Mr. Peterson. Sure.
And so, before we ask that question about circumstantial evidence, you had made the point that pretty much I made, that it's a difference between the guilty, not guilty, and then the sentencing. If he is guilty, does he deserve the death penalty? And so I have kind of convinced some people that there may not be enough evidence of death penalty, but that he's guilty, but not death penalty guilty. And I'm going to take that as a win for a minute, because a lot of people are really set on that he did it. But so this case obviously happened early 2000s, and he is now just getting a hearing for the appeal. Why do you think that this is happening so many years later?
Well, there could be a myriad of reasons, but one thing that's eminently clear that people don't think about a lot when those people that want the death penalty is the fact that the appeals take a lot longer, and they're much more meticulous, and they can go all the way up to the United States Supreme Court. And will go all the way up to the United States Supreme Court, and there's habeas petitions, and there's all sorts of things. So when somebody writes an appeal in a death penalty case, they have to have the transcripts. They have to go over the transcripts. The transcripts have to be generated. They have to make their arguments, et cetera, et cetera. Now, does that explain why we're here 15 years later? I don't know that I can account for all that time. But the process is very involved, and we know it was like a 400-plus page brief, right? So, the diligence which must be imparted upon an appeal like that in a death penalty case can in some ways explain the delays, why it takes so long, because it has to be that meticulous, because whatever's argued in the California Supreme Court, there's separate issues for what's called habeas federal issues. Certain issues can be argued at the state level. Certain issues are reserved for the federal level. There was probably at some point in time, or has been, an ineffective assistance to counsel claim. So all those things go into when an appeal can actually be argued. And of course, once that 400-page brief is filed, the state gets time to counteract, make their opposing argument, and then the appellant can respond to that as well. So it might be frustrating to people, but it definitely takes a lot of time.
And you have a lot of experience in this, because can you explain what you did? Because I know you went into death penalty cases specifically in Arizona. So can you explain a little bit about your work in that specific arena and how it worked for you, and how trying and hard that was?
Well, certainly. I mean, the death penalty, and I referenced earlier how everything that happens in a death penalty case is looked at for all the way to the United States Supreme Court. Mm-hmm. So there is a heavy burden on the defense attorney to do the right thing, to do a diligent and vigorous job of defending their client, or the case and or the sentence can be overturned. Mm-hmm. And this is kind of what we're seeing in Scott Peterson's case, right? When we talk about the appeal, one of the issues was jury selection, were jurors improperly excused. Mm-hmm. And, so that means that, that's just exemplifies how a death penalty attorney has to be schooled in the ways of, selecting jurors properly so they meet the Supreme Court standard when somebody looks at the case 15 or 20 years down the road, say, you did the right thing. So there's a lot of pressure, there's a lot of preparation, there's a lot of duty involved in all of that. And, I talk about this, in the one-man show I think I referenced when we were on your podcast about, how draining and how vigorous that can be, because these trials are also several months long, and not just Arias's case or some of these high-profile cases. I remember trying a case that was a cold case that was several years old, and no victim's family, no defendant's family, nothing like that. About as simple as a death penalty case as you could have, and it still took 4 months. And had that client been sentenced, it still would have been reviewed. So yeah, the pressure's on there, because if a defense attorney doesn't do what they're supposed to do, then Mr. Peterson could get a trial down the road. Which, on a personal note, is always apparent to me when people attack me for doing a vigorous job for Miss Arias, because if I hadn't, she might very well get a new trial. And the same is true in Scott Peterson's case. No matter what side of the coin you're on, that kind of job has to be done, and it can be very draining on a personal level.
Sure. And I think you touched on the fact about jury selection and a trial by, media, already before he even walked in the courtroom. And we're seeing that right now, I think, in a case that's coming up that's breaking right now with the Rashad Brooks and the officer, Colleen, what's his last name? Officer Rolfe, and being charged, could be charged with first-degree murder, and it being a death penalty case if so. And I'm wondering, like, in that same situation, like, how likely is it for him to get a fair trial? Because it is inflamed on all sides at this point, and it's very heavily, televised. Would there even be an option for Detective Ralph to get, or Officer Ralph to get, a fair trial with jury selection?
Right, and that's the challenge that a defense attorney in particular makes, because a prosecutor's goal is conviction, and a defense attorney's goal is that justice is done, and they provide a vigorous defense. Mm-hmm. So, but you're right. We even saw in Scott Peterson, and it even happened in the Arias trial. You look for a venue that is not so saturated, and I don't know my counties in Atlanta, but the Atlanta area, whatever county would try that case, I imagine the defense attorney will seek to say, hey, there's so much publicity. There's ways to look at the saturation in media markets, things of that nature, to get that fair trial. And certainly, there are people that don't watch the news, or people that don't follow these things, right?
Sure.
And so you look for these people, but you look for that media saturation, and you do your best you can. And we see this in Scott Peterson too, right? With jury selection, you have to screen for pretrial publicity, and it came up in the the second Arias trial. Right in the first Arias trial, she was relatively unknown. By the time the second trial came around, she was a household name to a lot of people, definitely true crime fans. But some people some people managed to avoid her, right? But you have to, that becomes an issue. You have to look at that, because if you don't, what happens? The Supreme Court says, oh, they didn't make a motion for a change of venue. The venue was polluted. Therefore, a new trial should be awarded to the defendant.
Right. And so in Scott Peterson's case, the petition for the writ of habeas corpus has, I've read it, it's long, but there are 19 claims for why he deserves to for an appeal. And I'm not going to go through every single one of them because there's a lot. But there's a lot of Fourth, Sixth, and Eighth Amendment rights. We already said about the jury selection and impartial jury. But one of the big ones was presentation of false evidence in violation of due process and Penal Code Section 1473 regarding, and then there's a few things. There was Connor's fetal age at the time of death, by the state's introduction of false evidence of a dog trailing expert at the boat ramp at the marina, the state's introduction of false evidence that the bodies of Lacey and Connor could only have originated from the area in which the petitioner said he was fishing. So that's false evidence that was injected into the trial. So just on, not even specifically what that evidence is, but for any case, is that kind of, whoa, big red flag, there's false evidence, he deserves an appeal just on those kind of motions alone?
Well, they could be. I don't know that they're false flags, or I don't know that the evidence is false, but these are the kind of challenge that happens in habeas, because evidence can change and the viability of the evidence can change. When I saw that same argument regarding the dog scent evidence, and it came to mind, there was a man named Cameron Willingham, who was in Texas, who was accused of committing arson and killing his family. And it was based on the current state of scientific evidence at the time related to arson investigation. Well, after he was executed, it turns out that the science behind that had been debunked and updated, and therefore it really was an accident, and it happened too late. Ray Krohn's case here in Arizona regarding bike mart evidence and manufactured scientific validity that really wasn't, got him exonerated off death row. So these are the kind of things, when those death penalty fans get roaring, I say, look, this is what's going to happen. These things are going to be looked at, and the dog scent evidence and how it was interpreted may not be the current state of science now, 15 years later, or 4 or 5 years later down the road, when these habeas petitions are ruled upon, or the Supreme Court takes a look at them.
And I have a question, so the fact of the matter, like you said, some of those different things of being the, that evidence can be, changed based on, scientific advancements and things like that. Also, so this being such a circumstantial case, we've talked about this, and it was kind of a stretch to go for the death penalty. But here's where I kind of lie on this, and I wanted to get your opinion. The other case that comes to mind being circumstantial that didn't go well for the prosecution was Casey Anthony. Kind of similar in the amount of circumstantial evidence they had, because they didn't have, a specific place of death. They didn't have a specific, person that they could just say, oh, absolutely, it was her, or it was him. So why do you think that his went through and ended up in a conviction, whereas hers did not, with the same kind of type of evidence?
Well, boy, that is really hard to speak to, and I will say this too. Keep in mind, when Casey Anthony was on trial, I had my own problems. I was the lead counsel for Jodi Arias when that trial was going on. So again, I had my own problems. But look, it really depends, and we talk about. Some of the issues about the effectiveness of counsel. I don't know I believe Mark Garagos represented Scott Peterson, if I remember correctly. Did he do a good job? Was the jury selection, up to snuff? Were certain things done properly? Is that why he was convicted? Was pre-trial publicity, what played a factor? Who sat in the jury? There's just so many things that can play a factor in that decision, and that, and really ultimately, no matter what any party involved does, it's those 12 people that make the decision and their mindset that rules the day, no matter what a judge thinks, a prosecutor thinks, or anybody watching the trial thinks. It's only those 12 people.
Well, so speaking of Mark Garagos, so the biggest section of the habeas corpus is, and I'll just read this because it's long, but not too long. It says, petitioner was deprived of its 5th, 6th, 8th, and 14th Amendment rights by his counsel's ineffective assistance in failing to consult with and present the testimony of an expert in the field of fetal biometry, in failing to present the testimony of an expert in the field of dog scent identification, and failing to present the testimony of an expert in the field of movement of bodies in bays and estuaries, and by counsel's failure to effectively cross-examine the prosecution's expert, and in promising the jury that it would hear 3 categories of exculpatory evidence, which would prove that Scott was stone cold innocent, in quotes, and that by not fulfilling these promises and failure to present exculpatory evidence in general. And so that's a lot of ineffective counsel arguments. And I'm not Mark Garagos. Mark Garagos, great attorney. But so that's a lot of, did he effectively, was he an effective lawyer for Scott Peterson? And the biggest one for me is that exculpatory evidence. That was, people were waiting for it. And then when it didn't happen, it was like, where is it? Where you said you were going to bring it and you didn't bring it. And so with all, again, not per in the details of Scott's case, but based on all of those ineffective, counsel arguments, along with jury selection and along with false evidence, do you believe that Scott has earned an appeal trial?
You mean a new trial?
Yeah.
You said an appeal trial.
But a trial.
Okay. I don't know the answer to that question because I didn't follow the case long enough. But you got to remember too, these are just claims, right? So the state counsel for the state, whether county attorneys or attorney general's office, will respond and say, no, this is within the reasonable standard of care, because there is a plethora of case law on what defense counsel must do in a death penalty case. And part of that is, at the very least, consulting and collecting evidence that would dispute the state's case. So it'll be interesting to see what the state has to say in terms of, the habeas petition would be the feds, what they say about the standard of care that Mr. Garagos gave to his client. And it's a very high standard. And, it could be a matter of, it's not just a matter of does somebody get trial. It could be a matter of somebody getting a sentencing phase retrial. If they were ineffective in the sentencing phase, were they ineffective in the trial phase, which means they could get a whole new trial.
So that was one of the questions I had. that was one of the questions I had, because a lot of people last night were asking on Web Sleuths whether this was a petition, an appeal for a whole new trial, or was it just to vacate the death penalty and possibly end up with life in prison without the possibility of parole. Are both of those viable options here? Is that absolutely could happen either way, or is it one or the other?
It could happen either way, because there could be something they say, well, this didn't affect the guilty verdict, but it could have affected the sentence, because the circumstances of the offense, remember, and people hated this during the Arias trial and everything else. They probably hated during all these death penalty trials. The circumstances of the offense have to come out. All this evidence has to come out and be considered. And so, even between the two of you, you have different opinions on guilt and innocence, and certainly one of you thinking, well, there's no way there's enough to send him to death row, right? And those same considerations really are kind of done by the Court of Appeals to say, well, wait a minute, there was some evidence that maybe this dog, let's just use the dog sniffing evidence, that maybe this wasn't so viable, and that wasn't presented during the trial. Maybe it didn't affect the guilty verdict, but maybe it affected the sentencing. So it's entirely possible that that an appellate court, a higher court, a federal court could separate the two and say there's enough evidence of guilt, but how that the sentence is not on solid ground because some of these things weren't presented that could make a difference between life or death.
Sure. And I know Colleen has a question about the death penalty.
I do.
Let me ask something real quick before you go to it, because I want to get a clear idea of this. So California has not put anyone to death in a long time. They've put a moratorium on the death penalty at this point. They've paused all of them. So what is the reasoning that attorneys, the prosecuting attorneys still seek that level of punishment if they really know that it's never going to happen? They're just going to sit there for years and years and years and years. Why are they still pursuing that? Is there a reason for that?
Well, I mean, I think the legal reason is that they say, well, they believed that the punishment was appropriate to begin with. They don't feel any differently now. And if that moratorium is lifted, they feel like the person should be executed.
Okay. That makes sense.
Okay.
So as an aside, both Vance and I do believe in the death penalty, but I think we both agree that we want some strong, hard facts, evidence, not just some circumstantial evidence, but some, like, for me, I would like up to a confession in most cases. I said me, not you.
I know that that's not the part for me, but okay.
But so the issue with death penalty in the United States, and as a medical professional, I do have concerns, is, so just for our listeners, most lethal injections in the United States use a cocktail consisting of 3 drugs that subsequently render an inmate unconscious, cause paralysis, and cease breathing, and then stop the inmate's heart. But in 2011, the only American manufacturer of sodium thiopental, which is a vital part of that 3-drug cocktail, discontinued production and has now forced states to adopt their own lethal injection methodology. And some states have gone to only using 2 of them, or combining drugs, and can the single drug method can take up to or takes about 25 minutes to end somebody's life if there are no complications, compared with the 10-minute long 3-drug process. And so I think what they said is that it's the one that's responsible for actually stopping their heart, or no, that's the potassium. It's something where they just pretty much just stop breathing, but they're awake for it. And that it's considered cruel and unusual. And so that's one of the last parts of Scott's habeas corpus, is that the death penalty, as currently administered in California, is cruel and unusual and unconstitutional. So that, I guess, I feel like is more of a federal point, not just for their state Supreme Court, but in terms of the federal issue of looking at the death penalty in a whole, or based on just the lack of available medication. If that's, the reasoning, if that's the case, based on the way the lethal injection is given, and I believe in California, they only use lethal injection. They don't do hanging or firing squad.
Or chair, yeah.
Or the chair, yeah. So if that's the case, do not just Scott, but do the people on death row in California have that kind of weight behind their appeal, in that if the moratorium on the death penalty is lifted, that the death penalty act of actually killing them is not cruel and unusual.
Well, I guess I don't understand. They would be arguing that it is cruel and unusual.
Well, right, yeah.
So one of the reasons they assert that, and everybody is going to assert that in an appeal or in a habeas petition, in an appeal when it goes to the California Supreme Court, because I'm sure, like all states, California probably has a cruel and unusual punishment provision. Most states have similar provisions, and you're going to have a federal provision. What happens is that the attorney on the appeal or habeas will have to raise that issue in order for it to stay ripe should the Supreme Court ever change their minds and decide that this injection protocol is unconstitutional, violates the Eighth Amendment. So it is somewhat to a degree a standard argument related to the protocol, so that if someone is, their appeals denied, they're set to be injected, set for lethal injection, a moratorium is lifted, they have that argument preserved, so they can retain that and bring that up to the court related to the injection protocols, because we're talking, keep in mind, 10 to 15 years down the road, the Supreme Court's going to be made up of totally different individuals, or a majority totally different individuals, and the law may have evolved and ways of execution may have evolved. So they preserve that in order to preclude the execution.
I see.
That makes sense.
So in you have you had a chance to go through the petition itself, Kirk?
No, I haven't. It was like 400 some pages. No, I have not.
I was just going to see if there was anything that you thought stood out to you as something that would probably be a big point for them, or something that you thought was, hey, that is interesting, that's odd. I just didn't know if you had really thought of anything that you had seen or heard, maybe that you thought would get him through this.
No, I mean, it seems standard in the sense that you're going to attack, in a case like this, you're going to attack the viability of some of the scientific viability of some of the, evidence that was used to convict. You're going to go back and you're going to attack what the attorney did. The appellate, the post-conviction relief people are going to say, this is why, he was convicted, or this is why he got the death penalty, because they didn't do this. So it's pretty standard fare, and they're going to make sure that all the rights are preserved in terms of what we just talked about, the cruel and unusual punishment aspect of things.
Mm-hmm. So I guess I want to round that out with, you did work in the death penalty cases. Do you have feelings or opinions regarding the current practice of the lethal injection without having the full 3 drugs?
Well, it is concerning when we hear some stories, and I can't remember, how many years ago it was, we've had, I can't talk now, failed executions where, the person suffered. I'll readily admit that the perspective I share is from the perspective of a guy who is anti-death penalty. I have concerns about the protocols that are being used, the failed attempts, and that sort of thing. So yeah, it does bother me, because I think when we start disregarding the cruelty in the manner that we kill the person, the government moves closer to being every bit as bad as the killer themselves.
I do agree with that. And I think, unfortunately, as technology has advanced, we see this amount of evidence tested after the fact that people have been innocent who have been put to death. And I know that must be insanely frustrating, not as a human, but also as a defense attorney, that you knew your client was innocent, but the jury decided they were put to death, and then evidence that is tested, 15 years after DNA evidence is proven, and especially in rape cases, and it turns out it wasn't them, and they died for something they didn't commit. So that must be frustrating.
Yeah, I mean, there's no doubt about it, and I've certainly been in the company of attorneys who were in that situation, not necessarily where their client was executed, but when their client was later exonerated, and the stress of knowing that could happen, and their work stood between it. I think I referenced earlier the Ray Crone case. And if you're not familiar, Ray Crone was an Arizona case, and there was some bite mark evidence. And Mr. Crone spent like 12 years on death row waiting to be exonerated. And I think there's a lot of pressure. And yeah, it only gets worse. And I mentioned this gentleman in Texas, where the arson investigation turned up later to be scientifically invalid, that led to his conviction. I'm sure his attorney feels terrible. And, that goes another reason for my opposition to the death penalty isn't just, the death penalties the defense attorneys get put through the ringer, but there is so much research that talks about jurors having PTSD in death penalty cases. Sure. And I talk about, I've been in courtrooms where the death verdict was rendered and jurors were in tears. There's no celebration. The victim's family was in tears. There's no celebration. There's nothing, to my opinion, there's nothing good that comes from it. And the mistakes in the process, and an irreversible type penalty like that is just something we can't, in a culture that bases itself on not being cruel, there's something we just can't shrug our shoulders at.
Well, so there's so much, or so many cases in our country that old DNA evidence hasn't been tested. Now that we have the capability to test it, that could potentially exonerate thousands of people across the country. Is there a way for just run all the old evidence and that wasn't able to be tested, from like 95 and before?
Well, this is the kind of thing that, I'm sure you've heard of Barry Scheck's Innocence Project, and there are law schools around the country that advocate just for this with these special cases. But we also see, and we had a situation in Arizona where, I don't know the number, but a high number of rape kits and different things weren't being tested. They're just backlogged and they weren't going for it. So, it is concerning that if we're going to have a criminal justice process, that we fund it properly so these sort of things can happen and these sort of mistakes don't happen. But there will always be advances in science that are unavoidable. The question is, are we willing to make those kind of mistakes along the way until science catches up and the penalty is irreversible?
Sure. Well, we thank you so much tonight for joining us, Kirk. It's always a pleasure. We had a great time. His podcast about Jodi Arias is going to be coming out here in a couple of weeks because we're preparing our stuff to go with it. So we're really excited about that. But thank you so much for joining us tonight. We'll have you back. We're going to have him as one of our regular guest folks. So you guys, if you have questions that are legally charged in cases, send them to us so that we can ask Mr. Nurmi what he thinks. But thank you so very much for joining us tonight. We really do very much appreciate it. Okay. Well, have a great night.
Next time I will comb my hair and you will see my face. How about that?
That's great.
Right. Absolutely. I mean, pants are okay, but I mean, they don't,
as long as it's from the waist
up. Waist up. It's optional. It's funny.
All right. I'll keep that in mind.
All right. You have a good one.
All right,
okay.
ladies.
All right.
Thank you so much.
You did a good job. You did a good job. I truly do believe you guys are right about the death penalty with his case. I can give you that. I really can.
And I'll take it as a win. I'll take it as a win.
But do I think he's not guilty? No, I really truly believe that with the circumstantial evidence and the evidence after the fact, I truly believe that is all indicative of him being very, very guilty. I think that, I do think that it plays a part of the trial, trial of media, in the public opinion. I do believe that. Which was why I brought up Casey Anthony, because it was just as much every bit of a trial in the public opinion that went the wrong way, everybody expected that.
It was a bad choice.
Everyone expected that. And I think that death penalty was the difference in that case of the death penalty had just been taken off. If it was just life without, parole, I think that Miss Anthony would have been convicted of even first degree if that had been the case.
Well, and Casey Anthony's attorney was a goddamn genius.
Oh, he was amazing. He's
brilliant. Just throwing in that doubt about, she was molested by your dad. Not true. But just you brought it up. Just a genius.
Well, it's the same. It's the same thing that we say about Gypsy's lawyer. That he took something so small in that case. I mean, and that's not to say that it's small. Okay, she went through years and years and years and years and years and years and years of lots of different things that are abusive, and I don't doubt that Gypsy was abused, but not everybody who was abused kills their mom, and she had many other ways out, and I think that she was very untruthful about those ways out.
Yep.
But I think that he did the same thing. I mean, he picked up on something he didn't even have nowhere near the amount of files that we have, and was able to create this narrative of, oh my God, it's Munchausen by proxy, this poor girl. Let me get some experts to say it. Let me Let me grab Mark Feldman, who's not going to look at the case, but he's going to say it, and convince the prosecuting attorney that he really had more than he had. I do. I think he was brilliant. But
I'm excited for the. I believe that the amount of information we have now and the technology we have now, I do believe that Scott Peterson is going to get a new trial.
I don't know if he's gonna get a new trial. I think he definitely might get a reduction of sentence. I think that's what's gonna happen.
I mean, there's a lot of evidence.
I don't think anybody wants to give him a new trial. I really don't. I don't think anybody wants to. You are so in the minority of that. Like, even with attorneys, psychologists, doctors, forensics.
But it's not about the general public opinion.
No, but I truly believe that it's going to, I think most of it's going to be looked at, all right, death penalty taken off the case. I don't think he's going to get a new trial, but that's just my personal opinion.
Well, okay. Well, if he does, I am ready for it. I am excited. I want to hear all the new things that they are going to say. I want to hear from Scott.
I would say that would be interesting to me too. Okay. I'm not saying I hope he doesn't get a new trial. In fact, I almost hope he does, because if he does, I think he's going to be found guilty again. And I think that that's going to end the conversation about it. Like, it's no longer going to be, it was circumstantial or blah, blah, blah. No, it's going to be like, oh, nah, that guy is totally guilty. And I think
because there's be enough technology and enough evidence now to say, I would accept the results of a trial now versus the trial that happened in 2005.
Sure.
I think Garagos made mistakes. And again, that exculpatory evidence, he did not provide it. He said he had it. He didn't. He said, I will prove to you.
But what if he just didn't have anybody to refute it because there was nobody who could refute it?
But he said, no, but the issue is that he said it to the jury that he had it. If he didn't have it, he should have not said it.
Maybe he thought he had it, and then through the basis of, I mean, there are witnesses that change their opinions all the time, especially if something came up through the matter of one of those pieces of evidence changed, or a test result came back different that he thought wasn't going to come back different. Then his expert witnesses may have not wanted to testify. I mean, I'm not saying,
but they would have had the transcript of their statements that they already had given.
But they can't use that. They'd have to be able to be cross-examined, Colleen.
I mean, yes, but the issue is that I think that he had it and that he didn't provide it, or he didn't have it at all.
Well, I think,
and then he should have said it.
I think he might have had it and thought that that the jury would understand it. And when the other experts testified, I think he realized, I'm over a barrel here. I'm not going to have it. I really do. I think that is an issue in this case. I think and I don't think that's ineffective counsel. I think that means, oh shit, their witnesses are just way better than mine.
But you still gotta at least throw up an expert to counteract.
Well, not necessarily, Colleen, because that can go bad for them. If you throw up a bad witness, or a witness that you think is going to go your way and it doesn't, that can tank your jury like that. I mean, and so it's better to not put something forward than to put something forward. Maybe he thought, okay, maybe they don't understand it, and if they didn't understand it on their side, they won't understand it on my side. So I'm just going to let it sit that they don't understand it and hope that carries me through. I mean, there's a lot of different things that could happen.
Hey guys, so a couple nights ago, we launched a special campaign along with Cheryl McCollum from the Cold Case Research Institute called Love Wins. And what this is it is our answer to all the chaos that's kind of going on right now, the chaos from the riots, the chaos from all the different, pandemic, everything that's happening in our lives right now, all the issues with, the different lost lives that we've had from before the protesting, after the protesting. So all the lost lives that have come out of this, the lost lives of COVID even. And so #LoveWins is a movement to usher in peace, and knowing that above all, the only way that we're going to get through all of this is loving each other. So what we're actually doing here is we are creating a scholarship fund in remembrance of all the lost lives in 2020 so far, and ushering in peace. And this scholarship fund will go to anyone that wants to go ahead and enter to win. The criteria is really cool. All you have to do is make a 30-second video of yourself and explaining to us how you lead with love. And we are looking for college-age students that are, struggling. Maybe they can't get scholarships. Maybe there's a reason, that they aren't available for them, or it's just not enough for them. And so this is our way of helping out. We're hoping to raise about $5,000. If we raise more than that, then we'll look into giving more than one scholarship away. The way that we're doing this is we have some merchandise. It's #LoveWins merchandise. And there's also Lead with Love merchandise. They've got shirts, cups, mugs, stickers, anything you could possibly want. And we're going to have it on a couple different platforms. Currently, we're doing some on TeePublic, but I'm working on some on Cafe Press too, because they have a lot more variety of merchandise. And so we'll be donating a portion of the proceeds that we collect on this merchandise to the scholarship fund that we are creating. And then we also have a GoFundMe that will be listed in the show notes of our YouTube show and our podcast, and you guys can click on it and you can donate any amount you'd like, and all of the proceeds from that are going to go ahead and go to the scholarship fund. And we'll be showing you exactly how the money is distributed, how it's collected. We're going to be very transparent with this. We're working with some amazing professionals that from like Cheryl from the Cold Case Institute, David Lampley from the Oliphant Institute, the leading death investigator, Joseph Scott Morgan. So we're working with all of them to really show how much love wins over everything and bringing peace to a country that we really need it right now. So that's what we're doing. And we're going to go ahead and play our entries at the top of every podcast and every YouTube until we choose a winner. And our special guests that we have each week, the different people that come on and are here with us, Cheryl and Stephen and Joseph, they'll all be a part of choosing that lucky winner or winners, depending on how much we end up getting donated. So I hope that you guys join us in #LoveWins. And we hope that we get some really great entrants, because we really want to see how you lead with love.
Thanks so much for tuning in and dishing true crime with the Good Wives and Murder by Design. Don't forget to join our Patreon member club to get exclusive mini episodes, inside documents and pictures from the case, live YouTube discussions, our exclusive discussion group on Facebook, and get some amazing Good Wives merchandise.
And follow us on Twitter and Instagram at True Crime Wives. And for more inside information, check out our podcast, The Good Wives Guide to True Crime, on any of your favorite podcast players.
Have a good one from the Good Wives, serving up true crime one dish at a time.